Well, hello. Thank you so much for being here. Will you please introduce yourself?
Sure. My name is Michael Gans. I was formerly clerk of the United States Court of Appeals for the Eighth Circuit for many years. And I worked for the court when the Kuhlmeier case was before the court.
What is your background in law?
I'm a graduate of Washington University School of Law here in St. Louis. I was a law clerk in the Missouri Court of Appeals, practiced law for a few years, and then came to work for the Eighth Circuit, first as chief deputy, and became clerk of court in 1992, and I retired in April of 2024 from that position. I am currently practicing law in Clayton with the firm of Dowd Bennett.
What are the clerk of court and chief deputy clerks of court?
Well, they are the court's top administrators for daily activities of the court. The court, Eighth Circuit, hears about 3,500 appeals every year, covers 7 states, employs about well over 200 people, and there's a lot of daily activities that go with filing cases and answering problems for lawyers and judges and issuing the court's orders and decisions, and kind of serve also as personnel officer. It's like a little business. I have about a $5 million budget when I ran the court, so there's a lot of work to do.
So what happens at a court of appeals?
Well, the courts of appeals in the federal system are what we call courts of error. Our job is to make sure that the district court followed the correct procedures in the case, applied the law correctly, and came up with the correct decision, instructed juries correctly if there's a trial, things like that. Well, we're not here to legislate or come up with our own decisions. We're here to follow the law and apply it as best we can to new situations as they come up.
What is your connection to the case?
Well, I was chief deputy when the case was before the court back in 1985, I believe that was right. And before I came to the court, I had practiced in the area of school law, representing a couple of the St. Louis suburban school districts. So I had a real interest in school law. And even though I had been with the Court of Appeals for a couple of years, I still continued to follow school law cases as they came up. This wasn't a particularly difficult case or troublesome case as it was getting ready to be heard by the court. So I can't remember that I actually had anything to do with it, but I certainly knew some of the lawyers in the case, including Bob Haar, quite well. And I had followed the case in the newspaper and kept tabs on the briefs, things like that.
Were First Amendment cases rare in the Eighth Circuit?
Not as common as they are in some other circuits. Certainly in the West Coast and the East Coast, where they're East Coast with the newspapers and magazines, and West Coast today with all social media giants. Eighth Circuit's kind of here in the middle in flyover country, and we have for occasional First Amendment cases. Obviously, of course, Tinker, one of the main First Amendment cases came from here. We have them occasionally, but they're not a large part of the court's caseload.
Were you there during the oral argument?
I know I was, but if you ask me, what did I think, or who won, or who was great, or what questions the judges asked, I really couldn't tell you. In 41 years here, I probably heard 15 or 17,000 arguments, and unless something's really unusual, it doesn't really stick out.
Did you know the lawyers or judges on the panel?
I knew the judges quite well, obviously. They were my bosses, and especially Judge Haney and Judge Richard Arnold, who'd been on the court quite a while. And I was good friends with Judge Wollman as well. He had not been on the court too long when the Kuhlmeier case was heard, only about 2 years. But yes, I did know all the judges, and I did know some of the lawyers, like I mentioned, Bob Haar, and I can't remember who else was in the case right now, but I certainly knew Bob quite well. I had worked on the St. Louis school desegregation case as a practicing lawyer, and Bob was one of the lawyers, I believe, in that case as well.
So there was another case moving through the federal courts at the same time, Bethel versus Fraser. How do judges find out about similar cases, and how much weight do they have in the decision-making process?
Well, obviously, it's a lot easier today since the federal courts have adopted a nationwide electronic filing system that allows you to look at every document, every case, from your desktop. Back then, you kind of had to know what was going on. There wasn't as much coverage in legal newspapers, online, blogs, and things like that. You might have heard of a case, or maybe you knew of a judge in another circuit who was working on a particular case. But sometimes you didn't know what was going on with similar cases around the country. There just wasn't an easy way to keep tabs on it. As far as how much weight they get, only decisions of the Supreme Court and the Eighth Circuit itself are what we call controlling, or we have to follow our own law. Decisions by other circuits are interesting, might be persuasive, might not be persuasive. It depends on how close they are on point and whether or not the court wants to adopt the reasoning of that case in light of the other decisions that we've made over the years.
Do you think the judges would have made the same decision if the case was heard today?
Well, that's an interesting question. Certainly you would say, if you were looking at Judge Haney's record, that he was what would be called a liberal judge. He had been a member of the Democratic Farmers Party and close friends with Vice President Hubert Humphrey and Walter Mondale. So he was a progressive Democrat back in the 60s and 70s. Richard Arnold's a little harder to tab, but certainly I would say he was more liberal than you might expect of a typical circuit judge today. Judge Wollman was more middle of the road. He had served on the South Dakota Supreme Court as chief judge there and was well respected without maybe a real ideological bent to his decisions or his work. Today, you have to look at the compositions of the court and how they've changed. I would say that most commentators would believe that courts have moved to the right, more conservative than they were, was that almost 40 years ago. So it might not turn out, it probably would turn out the same way in the Supreme Court that it did. Whether it would turn out the same way in the Court of Appeals or not is a different question.
So were you surprised when the case made it to the Supreme Court?
No, I thought it was an interesting case. I thought it had a lot of application. Obviously, it had a lot of publicity locally in terms of its importance to schools and just people are interested about what their kids see and do, and that hasn't changed. I mean, that's still a big part of our news. And look at the situation in Florida and other states. I mean, what's taught in school, what's done in school is still a hot political issue. So it's not surprising to me that it made it to the Supreme Court. It quite clearly presented an opportunity for a court that was different in composition from the court earlier that, I'm going to stop for a second. I guess we can always edit this out. I can't remember the other case, our big case with the armband.
Oh my God, the Vietnam War one.
Yeah, I can't think of her name.
Oh my gosh,
That's terrible.
It's the
when you get to be 72,
we just talked about it.
When you get to be 72, you'll find out the names often escape.
You're going to search it?
No, that's okay.
Okay.
It'll come to me as we talk. But, it presented an opportunity to take a new look at the law, a new court, take a second look at the law, maybe clarify it. And it didn't surprise me that the Supreme Court took it.
Were you surprised with the Supreme Court's ruling?
No, I was not surprised with the Supreme Court's ruling either. The court had changed over the period since the Vietnam War, and it did not surprise me at all that was the ruling. Plus Judge Wollman, when you read Judge Wollman's dissent and you read the district court judge's decisions, they are, carefully argued and reasoned. It's a question you can come down either side of. I mean, there's support for either side of this argument. It's just, what do you value most? And that's a personal decision, and it will change over time as new judges take a look at these questions.
So back then, did you think that this case would be so impactful today, that students would be studying it today? Yeah.
Well, that's a really good question. I'm not really sure, at the time, probably not, but back then the Supreme Court decided almost 100 cases every term, and it's hard to say which of those are going to be impactful or not. Some are not going to be. If you're, interpreting some provision of the Internal Revenue Code, that's going to be of significant interest to a very small number of people. Then there's going to be cases that deal with social issues, whether it's school integration or First Amendment rights in schools or voting rights, whatever it might be, that are going to be more impactful and are going to have long-term consequences. I guess, if you really thought about it, this is probably the kind of case that might have impact for a long period of time, and certainly it's still being referred to and relied on today. So, of the cases that term, this was a fairly impactful case.
So why do you think this case stands out beyond others and continues to be studied today?
Well, I think it's really important. We live in an information society today, and that applies to just about every American at every age. Whether you're a teen influencer or you're blogging or you're writing a column, whatever it might be online, your social media posts. I mean, it's really of great consequence. I mean, what we say and when we can say it and how we can say it and what consequences what we say might have is something that is, right at the very forefront of the most important issues in our society. And I think, people feel very strongly about what influences kids should see, what they should be able to say. And certainly in the school setting, all you have to do is look at some of the states that have, micromanaged their curriculum to the point where, you can't say this or that word even. It's not surprising that a decision that gives school boards and school authorities greater control over student speech is still of consequence today.
Thank you so much, Mr. Gans. I'm very happy to have interviewed you.
Thank you. It was great to meet you, and good luck to you.
Thank you so much.